Hi, this is Professor Kamre Sandeep here, and today we are going to discuss about our next topic, that is treaties for intellectual property rights protection. Okay, so in our syllabus, totally three treaties are there, which we are going to discuss about. So basically, treaties means what? First of all, so treaties are again nothing but an agreement signed between two different parties. Okay, so here parties is mainly for considering two different institutions, or it may be two different states, it may be two different countries. Okay, or these are the nothing but two components. Okay, which going to do an contract or agreement for an particular thing. Okay, so this is treaties. Okay, and this treaty is maybe for anything. It may be trade related, it may be related to some memorandum memorandum of understanding. Okay, nowadays we are seeing about lot of MOUs are happening between countries. This is also an part of treaty. Okay, or nowadays if we discuss about our India, number of MOUs are there for production of number of products from different sectors in India itself. Okay, so this is also an agreement or treaty. So basically this is about the treaties. Okay, so now in case of intellectual property rights, why the necessity of these treaties? So as we discussed in our last lectures or in our syllabus so far, we have discussed about forms of IPR, then WIPO, that is World Intellectual Property Organization, WTO, GATT, then TRIPS. So all forms of intellectual property rights which we have discussed, that can be protected for a certain time period and in certain limitation of space. For example, if we are getting patent in India, or if we are registering trademark in India, it will be limited for the India itself. If our product goes outside India, there is a no value of that trademark. Okay, as far as we are discussing about trademark registration in India. Okay, so here when we are looking to protect our trademark or our literature which is created by number of authors, then how will protect it throughout the world? throughout the major countries of the world. Is it possible? Yes, it's possible because of these treaties. Mainly, these three treaties are there. First one is Madrid Protocol or Madrid Treaty. Second one is Bernese Convention, and third one is Budapest Treaty. This name you may heard about Madrid, that is capital of Spain. Okay, Spain is a country, and Madrid is the protocol of Madrid is the capital of the Spain. And this particular treaty or agreement, which was related to the protection of trademark, was signed in this particular place, that is Madrid. So it is called as Madrid Protocol. Second one, that is Bernese Convention, which was again with the place name, that is Bern is the capital of Switzerland, where this treaty was signed, so that it is also called as a Bernese Convention. And third one is Budapest Treaty. Again, it is a location in Hungary. It is actually capital of Hungary, where this treaty was signed, so that it is named as an Budapest Treaty, which is related to the protection of microorganisms which are newly searched or patented one. Okay, so in today's lecture, we will discuss about Madrid Protocol, and our next lectures will cover one by one all these three treaties. Moving on to the next slide. Okay, so Madrid Protocol. So first of all, we'll discuss about the background of this Madrid Protocol. The first point, many companies of India broadening their business into many countries, often analyzing the value of registering their trademark. Okay, so those companies, those producers from our country, that is India, they are broadening their business. Okay, in the foreign or in other countries also, they are doing business, they are exporting their things, and in these cases they very well knows the valuation of the registering their trademark. Okay, because the trademark, if trademark is registered, then only they will have a proper business. Otherwise it's quite difficult to make a business in other countries. Second, they are faced with copying and imitators. Okay, now in India, if you have registered any trademark, it's not necessary to follow other countries also. Okay, so producers from other countries will make same thing, or not exactly same but 90% same, and they will have benefits of economic benefits also, and some other benefits with related to the particular trade. So whenever these type of things are there, copying, at that time original producer from other country will have to suffer, his business will suffer. Okay, so this is why it is very much necessary that the trademark should be registered in other countries also, not only home country. Next point, the risk of doing so are very high, costly, and detrimental to a company's entire business and export strategy. Okay, so if somebody else is copying the things, then the original company, original producer have to suffer, and it's detrimental to his business. Okay, and export strategy also. So it's very important again to register your trademark in other countries also, so that you will get the protection in number of countries, which will help in the running smoothly the his business. Next point, it can be a serious financial liability to invest in a brand, promote it in the local market, then find that the brand cannot be registered and used internationally, and have to finally abandon that investment. Okay, so again, important point related to the trademark and the business or trading, which is, if we have produced we have made an brand in our home country which is not registered internationally, then whatever efforts have been taken to produce this particular brand, particular quality, which will be having no value, then what is the use of that particular investment behind making the brand? Okay, so that it's very much necessary that you should register your trademark internationally. And Madrid Protocol is mainly for the protection of or registering the trademark in worldwide or major countries of the world. Moving on to the next slide. Madrid Protocol was adopted in 1989, came into force on December 1st, 1995, and came into operation on April 1st, 1996. And both treaties were adopted at conferences held in Madrid, Spain. As we discussed, it was signed in Madrid or accepted by a number of countries in Madrid, so that it is called as Madrid Protocol or Madrid Treaty. With respect to our final theory examination in the objective, mainly these type of questions are there. That is, Madrid Protocol was adapted in dash. Okay, so year also important. Was adopted in 1989. Came in action or operation, that is in 1996. Next point, that is the application of treaties is governed by two texts: the common regulation or the regulation, and the administrative instructions. Okay, so here, whenever such type of treaties are there, agreements are there, there is an documents created having directives related to that agreement, in which particularly under these words, the common regulations, the administrative instruction, number of directives are given, and these are the mainly two texts of Madrid Protocol. Mainly in the common regulations, it is given that a brief general introduction to Madrid system. Again, it includes explanation on how a state can become a member of the Madrid. In part A, then again it includes explanation of membership of the Madrid Union. Then in the part B, deals with the procedure, and it is again in two parts. in which chapter 1 deals with general question of procedure such as modalities of communication with the international bureau, the calculation of time limit or the language region. Okay, so as it is an international agreement, international treaty, so that number of languages to be used by different parties or different countries which are the members of WIPO. As the World Intellectual Property Rights, that is WIPO, is an highest authority who is performing all these operations related to the protection of trademark. Second one, that is chapter 2, describe the international registration procedure as well as other procedures which may concern an international registration. Okay, all these things are given in particularly part A and part B. Broadly, we are not going in deep what are the general instructions and all those things as per our syllabus concern. We will discuss about the major points related to Madrid Protocol. Then next, one more important thing is that Madrid Protocol is also called as an TLT, that is a trademark law treaty. Okay, so as it is mainly related to the trademarks, it can be called as trademark law treaty. Now, what kind of marks, trademarks can be protected in the Madrid Treaty? That is also one of the important point. So, first of all, this treaty shall apply to marks consisting of visible signs, provided that only those contracting parties which accept for registration three-dimensional marks shall be obliged to apply this treaty to such marks. Okay, so basically, the marks which are visible in nature. Okay, sometimes there are marks which are generally we are unable to see by our naked eyes. Those type of the marks are also there. Okay, for identification of the good, but that type of marks cannot be covered, cannot be registered under this treaty. Three-dimensional marks are also there, which should be protected under the Madrid Protocol or Madrid Treaty. Then this treaty shall not apply to the hologram marks and to marks not consisting of visible signs, in particular sound marks and olfactory marks. So hologram marks. Okay, hologram marks are one of the example of this hologram marks is there. That is the marks which are there on the particular jewelries. Okay, yeah, that can be classified as a hologram marks, which will not be covered in our Madrid protocol. And another one is there, that is if any trademark which is not consisting visible signs. Okay, signs, it may be in any form. Okay, it should be visible. That is the main point. Now, sound marks. What are the sound marks? So sound marks are nothing but an particular sounds which are related to particular producer. Okay, nobody else able to copy that, or it is unique to that producer. That can be a sound mark. But these sound marks are not covered in Madrid Treaty. And also olfactory marks. Olfactory marks means an unique sent, okay, to that product is olfactory mark. So all these marks, olfactory marks, sound marks, hologram marks are not considered for the protection in Madrid Protocol or Madrid Treaty. So basically, important thing is that the sign should be visible, clear, then only which can be protected, which can be registered for internationally through Madrid Protocol. Kinds of mark. Now here marks are related to the goods and services are there. Okay, as trade is concerned, in trades and services, the trademarks or service marks both can be covered in the treaty. This treaty shall not apply to the collective marks, certification marks, and guarantee marks. In our last some last lecture where we gone through the trademark, we discussed about the collective marks and certification marks. Certification marks are ISI marks, okay, which we have gone through the examples also. Then guarantee marks are also there, and collective marks are also there. So just go through our last trademark lecture. You will come to know what are the collective marks, certification marks. So this type of the marks cannot be protected through Madrid Protocol or trademark law treaty. Continue on to the next slide. The Madrid system may be used only by a person or legal entity which has real and effective industrial commercial establishment in or is domiciled in national of country which is a party of the Madrid Agreement. This is one of the important point with respect to the registration of trademark through WIPO. Okay, that is, for example, I have some product and I also have some trademark. I'm looking for registering this trademark internationally. In this particular case, India should be the member of Madrid Protocol or Madrid Treaty. What it means? It means India should sign this treaty or agreement. Then only I am able to approach World Intellectual Property Organization through Office of Origin, which is located in India, and then only I am able to register my trademark. Otherwise, it is impossible. Okay, so that the person or institution, whoever willing to register their trademark internationally, that country itself should be the member of Madrid Protocol or Madrid Treaty. Then only the registration of the trademark is possible. Second important point, that is Office of Origin. Now this Office of Origin means what? Office of Origin is the office of the contracting party with respect to which a person or entity fulfills one or more of the above condition is referred to as the office of origin. Okay, means what? India should be having agreed with this Madrid Treaty, and I am from India, domiciled India. Okay, then only it's possible. And the office which is fulfilling all these documents from India to the World Intellectual Property Organization. So this office, which is located in India, will be considered as office of origin, or this India is considered as a office of origin, as the India is the party of this Madrid Protocol. Okay. Next, an application for international registration must be presented to the International Bureau through the Office of Origin. Okay, as we discussed, International Bureau is nothing but the World Intellectual Property Organization, who is whole responsible for registration of trademark internationally. So it's responsibility of the Office of Origin to go to the WIPO regarding protection of trademark or registration of the trademark. Next important point, international bureau, where international application complies with applicable requirements. The mark is recorded in the international register and published in the WIPO Gazette of International Mark. Okay, so these are the advantages taken by the international bureau, that is World Intellectual Property Organization, where they will get required documents from the office of origin, and they will register it in international register and publish in the WIPO Gazette of International Mark. And once it got published, it will be, and particular trademark will get protected in the other countries also. Okay, then moving on to the next slide, Madrid, the international trademark system. Okay, why? As we know, it is an international trademark system as it concerns the protection of trademarks throughout the world. The one, it is a convenient and cost-effective solution for registering and managing trademark worldwide. Okay, one of the important point. For example, just consider that there is a no WIPO. Okay, so in these cases, you need to go for each and every country, and you need to follow all these countries, whatever processes are there, different processes are there. Okay, so that it will be very much costlier, and nobody is willing to do this particular thing. Okay, not only costlier, but it also time consuming. Then language issue is there. You may need to hire these translators. You need to pay for them also. So basically, it is because of the Madrid Protocol or Treaty, it's very convenient and cost-effective solution for registering and managing trademark worldwide. Second, by single application and pay one set of fees to apply protection in up to 121 countries. Okay, today it may be some, this number may get changed from 121, but basically whatever parties, whatever members of the Madrid treaties are there, or in all those countries you will get protection once you get filled only one form and only once fees for that particular filling of application. Third, modify, renew, or expand your global trademark portfolio through one centralized system. Once you got registered in that particular trademark, you may able to modify, you are able to renew that, then you may able to expand your global trademark through centralized system. Okay, you don't want to go to any or particular countries for the expansion of your trademark renovation and modification. Around 1.3 million trademarks registered. Okay, till date 1.3 million trademarks got registered in this WIPO's international register. Next, the Madrid system is the top choice for international trademark registration among export-oriented brand owners. Okay, as we discussed in our very first slide, if any businessman is there, any producer is there who is exporting their goods, and they have registered their trademark, then what is the value of that trademark? These businessmen should, these businessmen knows properly. Okay, if the trademark is registered, then only their good have the value in other countries also. Okay, otherwise they will suffer. So these are the some advantages of the Madrid Treaty. Then some features of Madrid Treaty as there. Again, first is convenient. Okay, the convenient means what? As we discussed in our first point on this slide itself. Okay, once you are filling only one form, you need, you don't want to go through single countries and fill the application. Okay, only one centralized system is there through which you are able to fill the form and you will get protected in member countries or the parties of Madrid Protocol. Secondly, global, register and manage your trademark in the territories of the Madrid system representing over 80% world trade. Okay, so in the world, what are the countries which are included or which are participating in world trade in export and import, out of which 80% countries or members are the parties of our Madrid Treaty. So that it's in the global nature, so that your trademark will get protected in major countries. And last one is cost effective. Cost effective, as we discussed, it saves time and also money, rather than a bundle of national applications. You only go for the only single centralized application, and you will get protected in the number of countries. Okay, so this is about the Madrid Treaty, which is mainly related to the protection of your trademark in all countries or throughout the world, so that you will get the benefit of that registered trademark in your business, or if you are doing your trade in the other countries also. Okay guys, so we will stop here, and in the next lecture we will discuss about Bernese Convention or Bernese Treaty, which is related to the artistic work and literature. Okay.